All right, Mr. Brown, we'll call docket 22-0196 LT. 22-1796 LT. That is Ronit Belkin versus Dasha Lee. Will the parties please introduce themselves for the record?
Yes, attorney Chris Brown representing plaintiff.
And ma'am, you are Dasha Lee?
Yes, that's correct.
All right. This is the time set for a formal hearing as the defendant failed to appear for the pretrial previously, but is present for the formal hearing. Ms. Lee, on September 7th, you were not here for the previous pretrial?
No, I was not aware of it.
All right. Mr. Brown, have you had the opportunity to speak with Ms. Lee about this matter? We set this for formal hearing because the defendants failed to appear. And the defendants here today. This is set for formal hearing, so this is the bench trial. Mr. Brown, have you had the opportunity to speak with Ms. Lee at all in this case?
I have not, Your Honor.
Would you be amenable to meeting with Ms. Lee in a breakout room?
Yes, please.
Ms. Lee, would you be amenable to meeting with Mr. Brown? He's a legal representative of Ronit Belkin. This is the time set for a bench trial in the matter. And you may want to talk to him to resolve some of the issues concerning this case.
Yes, that's okay with me.
All right, I'm going to have Mr. Brown and Ms. Lee placed in a breakout room.
Thank you, Your Honor.
Thank you, Mr. Brown. So we're back on the record in docket 2201796. Mr. Brown, did you have the opportunity to meet with Miss Lee in a breakout room?
I did, Your Honor.
And do you want to indicate what came of that for the record?
I do, Your Honor. Your Honor, Miss Lee has indicated that she has actually moved to Texas, I believe, she said. So I'm assuming the court would probably want her new address, as would I. However, there still is an item left. I think she indicated there's a trampoline left on the property that she's going to try to get removed today or tomorrow. So I guess one thing would be, do we have permission from her to have do we have legal possession back of the inside of the house, with the exception of the fact that she's going to come get the trampoline in the next couple of days, would be question number one. And then question number two, if the answer is yes, then I would like to adjourn, if possible, for 30 days for the purpose of going in, doing an assessment of the property to figure out what to do with her $700 security deposit, if we can get into the house and have possession back of the interior. Thank you, Your Honor.
Oh, all right. So first, Miss Lee, do you have a new address as to where you've moved for the court file?
Yes, it's 2479 Deer Run, DEER Run, apartment
Okay.
203.
All right.
And that's in Louisville, LEWISVILLE, Texas. Zip code is 75067.
75067.
067.
All right. The second aspect is on this is that so you don't have possession of the house. Mr. Brown's client, of course, would want possession of the house. There seems to be that this outstanding trampoline there. Would you be amenable, and I would, to allowing Mr. Brown the possession of the inside of the house so they can make inspection and indicate how the house is? Of course, I would sign an order to that effect for Mr. Brown, but I want to make sure and put it on the record that that's all right with you now that you're not in possession of the house.
Yeah, I can have my mother go over today and remove the trampoline. So as far as tomorrow and later, they could have possession of the inside and outside of the house.
How does that sound, Mr. Brown?
That sounds great, Your Honor.
All right. And then my preference would be to set it for a control date, set something for a control date just to make sure that and then we'd essentially wait to hear from you, Mr. Brown, on whether you've been, you let me know.
Well, we still have an issue with the money claim.
Right.
So if we could
But
possibly
you won't know about that issue with the money claim until you get in the house, right?
Right, but the balance right now is pretty high.
All right.
If we could by any chance get that court date, if there are any slots available on December 21st.
Yeah, I can set it for December 21st at 2.
That would be perfect.
All right, December 21st at 2 o'clock for formal hearing. And that would be on the money damages, right?
Yes, Your
Yeah,
Honor.
All right.
And I would ask, I'm sorry.
Go ahead.
I would ask if Miss Lee has her notice from the court in front of her, step one. And if she does, is my telephone number on it?
I actually don't have it in front of me right now. If you want to give me your number, I have a pen and paper here.
Because Your Honor, I would ask her to give me a call 24/7, leave me a voicemail, simply saying, I've removed the trampoline, nothing else.
All right. So Mr. Brown, why don't you provide your number to Miss Lee and she'll write it down.
Thank you. Ready?
Yep.
517-372-8500.
Okay, got that.
Thank you.
All right. So we'll set it on December 21st for 2 o'clock in regard to money damages. And at that time, there'll be some ability to go inside the house and see how it looks. And then that'll be the control date for how we're to proceed on this case Obviously, if Miss Lee is in Texas, we'll do that by Zoom.
Thank you.
Thank you, Your Honor.
All right. So our next date is December 21st at 2. We have certain things on the record. One is that the trampoline will be removed hopefully within the next day or so by Miss Lee's mom. Possession will then be granted to Mr. Brown's client, and then we'll leave the money damages for December 21st at 2 p.m. Anything else for the record, Mr. Brown, on 2201796?
Nothing at all, Your Honor. Thank you.
Anything else, Miss Lee?
Nope.
All right, we're all set. Thank you for your appearance today.
Thank you.
And then, Mr. Brown, you have Garno and Gerard. Is that correct?
Correct.
And Troy Bally.
Correct.
Is that your client?
Troy Bay,
Bailey.
however you pronounce it, is the defendant. Sorry.
Right. And your client would be Gerard Garno.
Correct.
Okay. So I'll call that case next. So we're on the record in docket 2201794. That is Gerard Garno versus Troy Bally. This is the time set for formal hearing. It was my understanding at the pretrial, defendant was to seek assistance from legal services, who was in this court and just left, but they did not file an appearance in this matter. It appears that Mr. Bally has failed to appear. This was scheduled for 1:30. It is now 1:57. Mr. Brown, how would you like to proceed today?
I've also received no notice from legal services or no calls requesting default be entered for non-appearance for both possession and money. And I can submit that to the court.
All right, default for money. Granted, and the order to be submitted to the court. And just for the record, Mr. Brown, to the best of your knowledge, Mr. Bally is not a minor, is not mentally incapacitated, is not serving in the military, and the rental unit was kept for the premises was kept for the purpose intended.
It was, Your Honor. Thank you.
All right. All right. Anything else for the record on docket 2201794, Mr. Brown?
Nothing at all. Thank you.
All right. Thank you. That's all for the record in that file. Then we have docket 2201795. That's Raz and Bakur versus Joshua Clemens and Jarman Shuri. This is the time set for formal hearing. Will the parties please introduce themselves for the record?
Attorney Chris Brown representing plaintiff.
And this is the time set for hearing. It was scheduled for 1:30 for Joshua Clemens and Jarman Shuri. It is now 1:59. For the record, there was a pretrial set in this matter. The defendant sought to seek the services of legal services of South Central Michigan. We do not have an appearance in the file from legal services. Mr. Brown, have you heard from legal services concerning this matter?
I have not, Your Honor.
All right. So it appears the courtroom is empty, and I don't believe that the defendants Clemens or Shuri are in the hallway. It appears the defendants failed to appear. How would you like to proceed, Mr. Brown?
Requesting a default be entered for non-appearance for both possession and money but money as to only, I can't remember, did both of them show up, Your Honor, at the very first hearing? Because I only have subs.
I have both. I have personal service as to Jasmine and subservice as to Joshua. I usually make a note if one of them did not appear. I have both, so I have appearance on both of them.
Perfect, Your
But
Honor.
that,
And
I'm just going by my notes on that.
perfect, Your Honor. And I didn't take good notes either. Sorry, to see if Josh showed up. I believe he did. I would be requesting a money judgment as to him as well. To the best of my knowledge, information, and belief, they are not minors in the military or mentally incompetent. And the apartment has been
All
kept
right.
fit and habitable.
All right, within that understanding, Mr. Brown, you'll submit an order.
I will, Your Honor.
All right. Anything else for the record, Mr. Brown, on docket 22-01795?
Nothing at all. Thank you.
All right, thank you, Mr. Brown. And it appears we have you at 2 o'clock, so we'll address those files. I don't see Vincent Hall at 2 o'clock here, but we'll give him some time to get here, okay?
Thank you, Your Honor.
All right, thank you, Mr. Brown. on the record in docket 22-02808. That is Elena Watkins versus Moa Abdullah Isa Mohammed. And then we'll put on your appearance, but your appearance is on the record. So Ms. Watkins, your appearance for the record.
Elena Watkins.
All right. And your appearance for the record.
Veronica Pereira, P79674, appearing on behalf of defendant.
All right. And I did receive an appearance from Legal Services of South Central Michigan concerning this file. And I've just, as a matter of fact, I'm just adding it to the file. This is the time set for formal hearing in the matter. And Ms. Pereira, well, Ms. Watkins, what is your understanding of how we're proceeding today? And then I'll let Ms. Pereira as counsel indicate for the record what's going on. So Ms. Watkins, how are we proceeding today?
I want this tenant out of my life.
All right.
He's damaging health of other people around
All right.
and damaging my house.
All right. This my only indication is how are we proceeding today? So how are we going forward with a formal hearing? It's set for formal hearing.
I want him out. I
Right.
don't know how you will proceed.
I don't know how to do that legally. All right.
Well,
So
do it legally.
all right. That's what you're the landlord. You have to do it legally. Okay. The responsibility is on you to do it legally.
I'm not agree with this all proceeding.
All right. Well, I understand, but being a landlord brings with some legal rights, and you have to follow the law in order to do those legal
I
rights.
don't understand why the landlord doesn't have a legal rights.
You
just
do.
tenants.
You do, but you've got.
I cannot read of this tenant for 4 years.
Right. But you have to go through a process. It doesn't happen
For
overnight.
4 years, I cannot read of this person.
All right. Ms. Pereira, how are we proceeding today?
Your Honor, we did file an answer with a jury demand along with the appearance. I mailed a copy to Ms. Watkins and I brought an extra copy for her today because I'm sure she didn't receive the copy in the mail yet. So I would just ask that Your Honor set this for a final pretrial conference and a jury trial date.
All right, we have it. I saw your demand for jury trial. So we will set it for final pretrial. And then we have a date set for jury trial. So the final pretrial date, we can do that a week before.
Okay.
Yeah. So let's set the jury trial date first because we have that. So it's set for jury trial set for jury trial on the civil docket.
January 18th at 8:30.
So January 18th at 8:30 for jury trial. All right, and then we'll set it for final pretrial.
Week before you are at judicial conference.
Yeah.
So.
So January 4th at 10:45. That Ms. Watkins, that's set, it's set for a final pretrial and a jury trial. And my recommendation, I don't know anything about the case, all right? I only know that it's come in front of me and it's been resolved once, all right? But it would be probably on onus, since it is a jury trial, to get a lawyer at this time, okay? To get a lawyer to represent and to follow the rules of the law, because we're gonna go in front of 7 people who are gonna make judgment, and they're going to do it based on your evidence. And there's rules that apply at jury trial, and you should have legal representation to come in and to prove your case concerning what you've alleged. We've gotten to that point, I think, in the proceeding. Ms. Pereira is a lawyer. She's here on behalf of her client. And so we're set now for jury trial on January 18th. So you need to talk to a lawyer, so you bring any evidence so they can legally admit it, so the jury gets to consider it. All right. I think that's the best advice I can give you at this point, is that because that determination will be binding. Okay. It's not unlike a trial just in front of myself, but the jury will be able to determine. I just make sure that the evidence is legally admissible so that they get to see it. All right. And then, so both of these dates you should take down so that you have it for any legal representation, okay? Because if you're seeking legal representation, and I think you should at this point, January 4th at 10:45 is the final pretrial.
Then,
Yeah, 10/4 at 10:45. And then January 18th at 8:30.
8:30 and he'll be here.
Yeah, 8:30 will be right here in person. Yeah. So usually we determine if we're going to call in a jury, and we've set this day aside for civil jury trial. The jury will be called in by 9 a.m. Okay. All right. Ms. Pereira, anything else?
No, thank you.
All right. Ms. Watkins, any questions? All right. We're all set. That's all for the record in docket 22-02-808.
Thank you.
And Ms. Watkins, now you know if you go see counsel that you know Ms. Pereira is the person to contact in this regard. Okay. All right. Thank you.
Thank you.
All right. So, sir, you are Vincent Hall.
Yes, that's correct.
All right. And this is the time set for a formal hearing in the matter. So I'm going to go ahead and call the case. Docket 22-01797. That is Mid-Michigan Wright Properties versus Vincent Hall. Will the parties please introduce themselves for the record?
Yes, Attorney Chris Brown representing plaintiff. And I have an observation, Your Honor. I wanted to make sure Mr. Hall is not actually driving right now.
I have a similar observation. You are Vincent Hall, sir? Is that I can't hear you. Is that a yes?
Yes.
All right. Are you driving, sir?
Yes, I just left work.
All right. I think you need to park for this formal hearing.
Okay, should I dial back in once I arrive at the station?
I'm sorry, I can't hear you.
Should I dial back in? Destination. It'll be just a few minutes until I.
When he reaches his destination.
Yeah, why don't you dial back in after you park your vehicle? This is a Zoom courtroom and we are scheduled to start a formal hearing.
Okay, I can do that.
All right. I had the same observation, Mr. Brown. Will stand by and we'll await to see. Have you had the opportunity to speak with Mr. Hall? I have that he was going to speak with somebody from Legal Services of South Central Michigan.
Right, and I have not had an opportunity. I just didn't want him to have a wreck. I mean,
Yeah, I understand the sentiment, Mr. Brown. All right.
Okay.
All right, so we'll stand by on that one. That one's in adjournment right now, okay?
yes, Your Honor. Thank you.
All right, so we're back on the record in docket 22-01797. Your appearance have been indicated for the record. This is the time set for a formal hearing on the matter. I see that this was set for formal hearing on September 7th. I have my notes indicate that Mr. Hall was present and wished to meet with Legal Services of South Central Michigan. I don't have an appearance from Legal Services. Mr. Brown, do you have any appearance from Legal Services?
I do not.
Mr. Hall, this is the time set for formal hearing. Would you like to meet, if amenable, would you like to meet with Mr. Brown to see if you can work out or resolve any issues before proceeding with the formal hearing?
Yes, Your Honor.
All right, I'm gonna have, Mr. Brown, are you amenable to that?
Yes, please.
All right, I'm gonna have Mr. Brown and Mr. Hall meet in a breakout room. So we're back on the record in docket 22-01797. That is Mid-Michigan Right Properties versus Vincent Hall. And Mr. Brown, did you have the opportunity to speak with Mr. Hall in a
I did,
breakout
Your
room?
Honor.
All right. How are we proceeding today?
Your Honor, I'm going to be requesting another adjournment on this one for the reasons that Mr. Hall has indicated that he is completely moved out. He has not returned his keys yet, but if he could indicate to the court that we can have legal possession back today, then that would be great. And I believe, and he could actually give to the court his new mailing address. I've already written it down, but I need to check it again to make sure I wrote it down correctly.
All right. Okay, so D is out of residence, but still in possession of the keys. And sir, do you have a new mailing address for the court file?
Yes, Your Honor.
Mr. Hall?
Yes, Your Honor. 220 West Madison Street, Lansing, Michigan, 48910.
And my understanding is that that you will be granting possession of the residence to Mid-Michigan Right Properties for possession purposes. And Mr. Brown, how did you intend to get the keys?
Your Honor, I would ask him to drop those off at my law office, and nobody's going to be here. We have a mail slot on the office door on every court notice of my address. He can walk into a building and he can put the keys through my mail slot and they can hit the floor. Just put sort of your name on it, but not the address.
Mr. Hall, will you be able to drop off the keys at Mr. Brown's office?
Yes, Your Honor.
All right. So we'll drop off the keys. The tenant is no longer in possession of the residence. We have the address for the record.
Your Honor, could Mr. Brown's address be emailed to me? I don't have a pen and paper in the car, so I could get that dropped off.
It should be in Mr. Is that on the Zoom notice? Is Mr. Brown's? No. Do you have access to the internet based on your Zoom call?
Yes, Your Honor.
Mr. Brown, is your office address on the internet? I am assuming. I'm just making sure Mr. Hall knows what building. It appears he doesn't know what building to drop off the keys at.
He gave me his email address previously, which is just
All right.
pushplay007@gmail.com, and I'll email that to him here shortly after the hearing.
Will that suffice, Mr. Hall, if he emails the address to drop off the keys?
Yes, Your Honor. Thank you.
All right. All right. Are there any order you can follow, Mr. Brown? You can follow this up with any orders that would indicate. But it looks like we put it on the record that possession has been turned over. The keys are to be dropped off at your office. There is an address for the record. And anything else?
Nothing at all, Your Honor.
All right. So anything else for the record in 22-01797, Mr. Brown?
Nothing other than, was that 1221 at?
The address was, I had 220 West Madison Street.
I'm sorry, for the next court date for the money claim. I apologize.
Oh, I'm
Your Honor.
sorry. The next control date would be December 21st. That was my fault. December 21st at 2 o'clock.
Thank you, Your Honor.
2:30? Yeah, let's go 2:30. I think I used my 2 o'clock time slots, so 2:30.
Yes, Your Honor.
And you've got, so December 21st at 2:30 is the control date for this. Anything else for the record, Mr. Brown?
Nothing at all. Thank you.
Anything, Mr. Hall?
No, Your Honor. Thank you.
All right, that's all for the record, docket 22-01797. docket 22-01919. That's people of the state of Michigan. I'm sorry. That is Bruce Kruger versus Tommy Thayer. Parties, please introduce themselves for the record. I've checked the Zoom courtroom. And I'll just check. I don't know what Alanda's iPad is. Let me just double check.
Amanda Sherman.
Okay, Alanda Sherman. And Mr. Dua. All right, so who's the one person? Who's Alanda? That's Alanda Sherman. All right. How about the other person? Mindy Johnson. All right. So I've checked the Zoom courtroom and I've checked the actual courtroom. It appears that Mr. Kruger or Mr. Thayer, they both failed to appear. I will state for the record that at the pretrial, the parties had entered into an agreement to turn possession over to the landlord by a certain date. And then we set it for formal hearing on this date. So that may have occurred already. And then the court wasn't notified. So I will dismiss this file for non-appearance of the parties. Right, that's all for the record, docket 22-01919. Ms. Johnson, are you Mindy Finley?
Yes, sir, I am.
All right, and your name's, so you know, you are no longer Mindy Finley, you are Mindy Johnson.
Yes, sir. Yep, they just haven't changed it in my records yet.
All right. All right, Mr. Brown, we'll call docket 22. I don't know if Mr. Brown's there or not.
Oh, I am, Your Honor. I apologize.
All right. No worries. So a call on the record docket 22-01798. That's Woodward 3 LLC versus Mindy Finley, now Mindy Johnson. Will the parties please introduce themselves for the record?
Attorney
Mindy-
Chris Brown representing plaintiff.
Mindy Johnson, defendant.
Okay, ma'am, you're Mindy Johnson. This is the time set for a formal hearing today. It was set for formal hearing on September 7th, 2022. My understanding is that you were left to make application with Legal Services of South Central Michigan. Mr. Brown, did you receive any appearance from Legal Services in this matter?
Not to date.
Ms. Johnson, are you represented by counsel today?
No, I'm not.
Would you like, so this is the time set for formal hearing. Would you like the opportunity to speak with Mr. Brown, a legal representative of, let me find it, Woodward's 3 LLC, in order to look at some of the issues involving this case today,
Yes,
rather than go to formal hearing? Mr. Brown, would you be amenable to that?
Yes, please.
All right. I'm going to have Ms. Johnson and Mr. Brown placed in a breakout room.
Thank you.
Thank
Clark, is that right?
Yes, Your Honor.
All right. So we're on the record in docket 22 0-01351 LT. That is LG Lansing LLC versus Scott Clark. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Hugh Woodrow, P56468, appearing on behalf of the plaintiff. I have sitting next to me the property manager for this particular property, Best Clark. Right? That threw me off because that's his name too. The defendant's also here, Your Honor.
All right, and you are Scott Clark, sir?
Yes.
All right. This is the time set for a formal hearing today, and I have been given a judgment, landlord tenant. Did you want to put any of the particulars of this on the record, or?
I would a little bit, Your Honor. This is a consent judgment I entered into with Mr. Clark. We are trying to work with him. He does have a Sarah Recert #2 number, but it's been pending since June, so we don't know if it's actually gonna go through or not. We are trying to work with him. He also, we believe, could qualify for Section 8, and I was hoping the court might have a legal aid attorney phone number that he could get in touch with to maybe assist him in that regard.
As a matter of fact, we do. Right behind you is legal aid. Right.
So be able to help you with the Section 8 stuff. So.
Yeah, and you'd be able to meet with them, and I know they have to make application. We also have Ulysses Rosa, who's our eviction diversion facilitator. That might be the better person to meet with today because he can answer any questions concerning that. Mr. Rosa, are you there?
Oh, yes, I'm here. Your
All
Honor.
right. So I don't know. I've got Mr. Clark here. He's entering into a consent judgment. However, there are some other issues concerning rental assistance, and I was wondering if you'd be able to answer any questions he might have.
It's possible. Yeah, you want to put us in a breakout room?
He's present live. We could put him on an iPad or have him come to your office, or you could come down here. I'm not sure where you are, so that's why I'm saying that.
Oh, I see. Generally, they put them on an iPad.
Yeah, let's
but
do that.
I don't,
So,
if you want me to come upstairs, I can come upstairs.
no,
either
we're
way.
fine. Let's put him on an iPad, but let's do this consent judgment first.
Okay.
And Your Honor, pursuant to the consent judgment, we are allowing him 30 days to move out. If the rental assistance comes through or he gets approval from Section 8, we're more than willing to extend that date, and we'll dismiss the case if that does happen.
All right. And for the record, I am signing with today's date the consent judgment, just to save time. That was signed. So that would put the date of appeal 10 days from today. So it'd be the first, it'd be October 31st. And then we will get you an iPad to talk to Mr. Rosa, so we get this thing moving. Is that your understanding, Mr. Clark, of what we're doing today?
Yes.
All right. I can have my assist, Mr. Nims, my court officer, make a copy. All right, and then make sure this gets in the court file. Anything else for the record, Mr. Woodrow on docket 22-01351.
No, we're all good. Thank you.
And anything, Mr. Clark?
No.
All right. That's all for the record in this file. Let me make some notes, and then I'll give you the file, and you can make the copies and place Mr. Clark on the iPad. Thank you, sir.
Thank you.
All right.
You want to just write something down straight, Rick?
And then the orders in there. Thank you. All right, Mr. Clark, if you follow my court officer, he'll set you all up, okay? Mr. Dewey, we can call your case. Or cases, I should say.
Thank you, Your Honor.
All right, so we're on the record in docket 22-01-859. That's Homes Apartment LLC versus Alanda Sherman. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Sam Dewey here on behalf of plaintiff.
Yolanda Sherman.
All right, and this is the time set for a formal hearing that was set on September 14th. I have a note here that the parties were going to attempt to resolve the issues. Mr. Dewey, have you had the opportunity to speak with Ms. Sherman concerning some of these issues?
I have not, Your Honor, but I would definitely take advantage of that opportunity at this point if it's agreeable to all parties.
Ms.
Yes, sir.
Sherman, would you be agreeable to meeting with Mr. Dewey in a breakout room?
Yes, sir.
All right. I'm gonna do that. So I can't promise you anything, but I'm gonna have Ms. Sherman, I'm gonna put you in room 3, and Mr. Dewey, I'm gonna put you in room 3.
Thank you. If you could put
And
Brittany from SimTop Management in room 3 as well, I would appreciate it.
Absolutely. All right, you should all get a prompt to go to room 3.
Okay.
Thank you, Your Honor.
Thank you. What tech- All right, we're back on the record docket 22-01798. Just for the record, I'm going to amend that this actually is Woodwork versus Mindy Johnson. Is that correct, ma'am?
Yes, sir. Thank you.
And you have no objection to me indicating that for the record that we're gonna change Mindy Finley into Mindy Johnson?
That's fine.
All right. Mr. Brown, you had the opportunity to speak with Ms. Johnson in a breakout room.
I have, Your Honor.
What came out of that?
Your Honor, Ms. Johnson has requested a 10-day adjournment. I said, hey, let's go 2 weeks to 14 for the reason of the fact that she has applied for assistance through DHS and CACS and is waiting for a decision to see what her copay is, if any, or if she gets approved. If she gets denied from both, she has the funds. She's indicated she has the funds to actually pay the entire amount that is due or close to it. And we've gone over those numbers. Thank you.
All right, so Ms. Johnson, you're at this time, you're requesting an adjournment in this matter in order to see what rental assistance is out there and what the number comes to. Is that my understanding?
Yes, Your Honor. Last time, the fiscal year starts on October 1st. So when I came in front of you last time, there was no funding. As of October 1st, started a new fiscal year, so every place has funding. So I was informed to go to DHS and CACS. I have done that. I'm just waiting on a letter.
All right, so Mr. Brown, we're looking at how many days out? And I'll try to see where we can. We're looking for a couple weeks, but
He said approximately 14 days.
In that case, Your Honor, let's make that 21 days at least. Right?
All right. What's the
I appreciate that.
14 might not mean 14.
I get it.
The closest I can come to that is November 30th for second formal hearing. or pretrial. But that's the earliest date I have, and that's just moving stuff around. So,
And that's
so,
fine with me, Your Honor.
all right, all right.
I'll
So
know
Miss,
something well before then.
all right, so Miss Johnson, the date, so we'll act almost as it is a control date, but the date is November 30th, 22. I'm sorry, November 30th. 2:45. At 2:45.
2:45, okay.
Yeah, on 2022, and you should have some more information. Ma'am, also, the city of Lansing has an eviction diversion facilitator, and I'm gonna give you his number in case you have any questions concerning rental assistance. I
No,
know you've done some of that on your,
I've already actually spoke to him. I'm already on top of that.
Okay.
He's the one
All
who
right.
directed me to these programs.
perfect, perfect.
Thank you. Thank you so much.
Then that saves me reading the number. All right, so we will be back here on November 30th at 2:45. Anything else for the record, Mr. Brown?
Other than to thank Mr. Rosa for advising the tenant to go to those agencies. Thank you.
Thank you. I have a
You're very
question.
welcome.
If I end up paying the money before then, do I have to show back up on that 30th, on November 30th? Or do I
would
just,
assume that I would assume Mr. Brown would let the court know if the hearing's required or not.
okay,
And one more item, Your Honor, and I apologize. I'd like to give
Sure.
or make sure Miss Finley / Johnson has my telephone number so that once she receives that notification of letter or approval or payment, she can let me know so I can file that dismissal with the court.
okay.
Are you ready to take that down, or do you have a court notice with my telephone number on it, Miss Johnson?
I do have a court notice, but it's I can't see the
You have
number.
a pen.
I do, yep.
Are you ready? It is 517-372-8500. Thank you.
37285, okay, thank you.
All
Thank
right,
you.
anything else for the record, Mr. Brown, on 2201798?
Nothing. Thank you, Your Honor.
All right, thank you. Miss Johnson, do you have any questions of me?
No, sir, thank you so much.
All right, you're all set. Thank you, ma'am.
Thank you, bye-bye.
All right, we're back on the record in docket 22011859. That is Homes Apartment LLC versus the Land of Sherman. Mr. Dewey, you had the opportunity to meet with Ms. Sherman in a breakout room?
I did, Your Honor, and we did have a successful meeting in the breakout room to the tune where we negotiated the terms of a proposed consent judgment for your review. I'd be happy to put the terms on the record for you.
All right, you may proceed.
Thank you. Proposed consent judgment would indicate that the defendant would pay to the plaintiff $2,040 in rent to retain possession through the end of this month, $163.50 in costs, totaling $2,203.50, again, to be paid on or before October 31st, 2022 to prevent writ from issuing. I have explained to the defendant that she was offered an opportunity to have legal counsel at the last time that we were here, and she appears unrepresented today. I advised her of her right that I'm sure you'll do the same regarding trial in front of judge or jury. We have both decided to proceed with this consent judgment. And finally, I requested of her permission to sign the consent judgment on her behalf, and she granted that permission to me as well.
All right, thank you, Mr. Dewey. What was the final number, just so I make sure I've got my math right?
No problem. 2203.50 cents.
Okay, thank you. Ms. Sherman, is that your understanding of the consent judgment agreement?
Yes, sir.
Did you hear anything that Mr. Dewey indicated that gave you pause, or that you had not already discussed?
Yes, sir.
All right. So that's just semantics. So you didn't hear anything that you're in agreement with that consent judgment, correct?
Yes, sir.
All right. You understand, you were here previously, that you have the right to trial by jury and you have the right to trial by bench trial. You saw the video, you understand your rights, and it's your decision to enter into this consent judgment and provide Mr. Dewey permission to use your signature in order for the court to sign. Is that my understanding?
Yes, sir.
All right. So I will await the order, the consent judgment order, to catch up with the file.
Thank you, Your Honor.
And the numbers are noted for the record. Anything else for the file on Mr. Dewey on file 22011859?
Yes, Your Honor, just briefly. The defendant is currently working with MDHHS as well as the Tri-County Office of Aging. But I don't think, if she's agreeable, I don't think it would harm her at all to speak with Mr. Rosa for possible other assistance that she may be entitled to.
That I am more than willing to after this hearing is done, to place you in a breakout room with Mr. Rosa so that you can discuss any further issues. Mr. Rosa, would you be amenable to that?
Oh, I will gladly assist, Your Honor.
All right.
Thank you.
So do you have any questions of me, Ms. Sherman, on docket 22011859?
No, sir, not at this time.
All right. Thank you, ma'am. That's all for the record in this file, and I'll place Ms. Sherman and Mr. Rosa in a breakout room.
All right.
Thank you, Your Honor.
Thank you. And then Mr. Dewey, I know that Ms. Pereira is speaking to her. I just got your appearance on the Angelique Larry case and Ms. Pereira's appearance on the Lakiva Osborne case. And so just so you know, that's the status of that case. Ms. Larry is here, and then Ms. Pereira is talking to her client.
Okay, yes, I do. I knew that my brand new client was there. I did not know that the defendant had appeared, and I do sincerely apologize for not honoring your in-person request. I just had no knowledge that I was even on this case until just literally an
No
hour
worries.
ago, so.
I just got Ms. Pereira's appearance also, so that works. I do have Mr. Roberts here on the on your final case for today. So let's, Mr. Roberts, you can come up here and have a seat. We'll go ahead and put that on the record. This is docket 22-01861 LT. This is Good Life Apartment versus Kevin Roberts. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Sam Dua here on behalf of plaintiff.
Kevin Lamont Roberts.
Okay. And this is the time set for a formal hearing. I have a pretrial was held on September 14th, 2022. And it was an indication that there was at least resolution discussions. Mr. Dua, have you had the opportunity to speak with Mr. Roberts concerning some of these issues?
Unfortunately not, Your Honor. However, once again, I would entertain the opportunity to do it today if it presented itself.
Mr. Roberts, would you be amenable to talking to Mr. Dua
Sure.
about some of these issues?
Sure.
I'm going to place you on an iPad, and then then my assistant, my court officer, Mr. Neves, will place you on an iPad and then come back and put everybody in a breakout room. Okay.
Okay.
All right.
Thank you, Your Honor. Once
So
again,
follow
if
my
I could
court
have Brittany from Simtop Management in there with us, that would be great.
All right.
Yeah, she's the one I talked to. I had talked to her.
Oh, she's on the iPad.
Oh.
Yeah. So our iPad is being used, so we're going to put you on as soon as we can.
No, that's all right.
Oh, you got it? Okay. I wasn't sure on that one. Alanda's iPad is all I saw. Oh. Let me see. Ms. Sherman, are you able to join? Do you see a prompt on your iPad to join a breakout room?
I don't see it anywhere.
You see any 3 dots that would allow you to join a breakout room?
Okay, I see the 3 dot. No.
You want to see if you could join room 1 or join a
Okay.
breakout room.
Let's see. I shoot. I'm sorry, Your Honor, I can't see it.
All right, let me bring Mr. Rosa back and we'll
Okay.
make sure that he has a contact number for you
Okay,
in order so that you can just talk on the phone eventually. All right.
that would be better.
All right. Mr.
Okay,
Rosa,
I
it
see you
appears that,
now.
all right, Mr. Rosa, it appears that Ms. Sherman is having some technological issues getting to the room. So would you prefer to leave? I could give her your number and then she can call you and you can talk on the phone with her.
Oh, yeah, that's perfectly fine.
All right. So Ms. Sherman, do you have something to write down this number with?
Hold on.
Okay.
What's the number?
All right. The number is 517-483-7608.
I got it.
And that should give you Mr. Rosa's number. All right.
Okay,
All right. We should be all set, Miss Sherman. Thank you for your appearance today.
all right, thank you.
All right, we're back on the record in 22-01861. That is Good Life Apartments versus Kevin Roberts. Mr. Dua, you've had the opportunity to speak with Mr. Roberts in a breakout room.
I did, Your Honor, and we did end up coming to terms on a proposed consent judgment for your review.
All right. Did you want to put those terms on the record?
I sure can, Your Honor. Let me do some quick math here.
All right.
Okay. Thank you, Your Honor. Proposed consent judgment would state that the defendant is obligated to pay the plaintiff $1,288 in rent to retain possession, $157.88 in costs, totaling $1,445.88 on or before October 31st, 2022 to prevent order of eviction from being issued. I did advise to the defendant that that he's waiving his right to have legal counsel today, as he was advised in the previous hearings, and that he is waiving his rights to have a trial in front of a judge or in front of a jury. And he has agreed to both of those, as well as agreed to allowing me to sign on his behalf for the consent judgment.
All right. Is there anything, Mr. Roberts, that you heard that was not discussed or that was not discussed by you already concerning the proposed consent judgment? All right. Is that a full, fair, and accurate statement of what Mr. Dua said? All right. And you've given Mr. Dua the authority to sign your name so that the judge can sign the order?
Yeah.
All right. So I will await the order to catch up with the file and sign it per the agreement. Anything else for the record? Mr. Dua.
Your Honor, I'm sure Mr. Rosa is quite busy, but this defendant would probably also benefit from the services of Mr. Rosa.
All right, Mr. Rosa, you be amenable to meeting with Mr. Rob? First
absolutely.
of all, Mr. Rob. All right, Mr. Roberts, would you like to talk to Mr. Rosa concerning some of these issues? He's the eviction diversion facilitator, and he may be able to answer some questions concerning rental assistance.
Yeah, do that.
All right. So we'll put you on an iPad, and I'll stick you in a breakout room with Mr. Rosa. He can answer some questions. All right. All right. So if you follow my court officer once again, we'll make sure you're in the appropriate breakout room.
All right.
All right. And then, Mr. Dua, if you're there, we will call the next case. So that is docket 22-01828 LT. That is Angelique Larry, and my understanding is represented by Samir Dua. And then there is Lakiva Osborne, and my understanding that Ms. Pereira, you're representing her today too. All right, so let's have all appearances for the record. I only indicate that because we received appearances today. So appearances for the record, Mr. Dua.
Thank you, Your Honor. Sam Dua here on behalf of plaintiff.
And Veronica Pereira on behalf of Ms. Osborne, and Your Honor, I have the paper appearance if I may approach.
You may, and thank you. All right, and then for the record, you are Angelique Larry?
Yes, Your
All
Honor.
right, and for the record, you are Lakiva Osborne?
Yes.
All right. This is the time set for a formal hearing in the matter. I understand that the attorneys just got involved in the case. So there's some question as to how we're going to proceed. I'll let Mr. Dua speak and then Ms. Pereira. Mr. Dua, you can indicate how you got retained and where we're going from here.
Thank you, Your Honor. Your Honor, this particular plaintiff reached out to me a few weeks ago, and I requested that she email me some information that that would help me decipher if we were going to pick up this case or not. And unfortunately, although she sent the email, for some reason it was not received by me. So we didn't speak again until early this morning when she called my office and was sort of wondering what was going on. But somehow, some way, we came into agreement. And again, I was just retained probably around noon. Today was the final agreement. I am familiar with the background of the case. I'm familiar with what plaintiff has not only prayed for at the time of the complaint, but what has occurred since then. And I would be very agreeable to talking to defendant's counsel in the hopes to resolve this matter.
All right, Ms. Pereira from the defense.
Thank you, Your Honor. So I also just entered my appearance on behalf of Ms. Osborne today. I did have an opportunity to speak with Mr. Dua a little bit earlier this afternoon, and so we did receive the ledger this afternoon, as well as he's raised an additional damages issue that was not pled for in the original complaint. And so I would ask at this time that the court adjourn the matter for a couple of weeks to give Mr. Dua and I some time to do some informal discovery and see if we can work out a resolution for the matter.
Mr. Dua, do you have any objection to an adjournment in this matter? I'd have to set it to I'd have to set it for a formal hearing date. But first of all, do you have any objection to an adjournment in this matter for some discovery between yourself and Mr. Pereira, Ms. Pereira?
Your Honor, with all due respect to Ms. Pereira, I would always honor her request, especially since we were both involved this late, for a couple-week adjournment. What I fear is that based on what you sort of indicated, I think we'd be going all the way out to mid or late December, knowing your docket and what we were assigned earlier today. The problem in this matter is that allegedly the city of Lansing is assessing many fines due to trash removal and nuisance fees that are occurring at the property. And it's already a fairly significant number. And I'm afraid with a 2-month adjournment that may increase significantly. Can you give me any indication as if I was correct as to the mid-December date that we would get?
Well, let's see if we can find an afternoon to hold this, a special afternoon to hold this. So hold on for a second and let's take a look at the schedule and see if we can find something a lot sooner than a December date.
If we can do that, then I think an adjournment would be appropriate, Your Honor. Thank you.
Mr. Dua, how about November 14th at 2:30?
Of course, we would have preferred a little bit sooner, but if that's your first available date, knowing that's probably 30 days or so sooner than we would have gotten, then it would be acceptable. And I would also motion the court for an escrow order for I've got $848 in rent that's still due for October, and then for the defense portion for November as well, before November.
All right, 5th. So let's schedule it for November 14th at 2:30 for the formal hearing. And then, Ms. Pereira, would you like to be heard on the escrow, the money to be put in escrow for the time being?
Your Honor, yes, I would like to I'll say that I was not prepared for an escrow argument, but to the best, argument that I can make at this time. This adjournment is a short adjournment. We're only looking at about 1 month. Ms. Osborne's rent at this time she's only behind currently for the month of October. And so I don't believe that plaintiff will be harmed by waiting for the November 14th date.
I think that's more in regard not to the rent. Is that in regard to the rent and fee and the well, go ahead, Mr. Dua.
Thank you, Your Honor. Again, with all due respect to Ms. Pereira, I disagree 100%. We're already at October 19th and the October rent has not been paid. We're going to be well into November, and there's no indication that the November rent would be paid as well. So I would request the court to at least, and to answer your question, Your Honor, the 848 that was paid for is simply the defendant's portion, the non-Section 8 portion of the October rent. I think it's a very reasonable request to have basically 2 months of rent owed, October and November, by the time we get to hearing, and only asking for 1 month in escrow.
All right, I think it's fair to ask for the October rent for escrow.
And Your Honor, just to clarify, that would be prorated to where we are in the month.
Yes, that would be prorated to where we're October, depending on when she pays, yes. Is that?
So it's my understanding that 848 is her tenant portion. Is that right, Mr. Dua?
That's my understanding. And to answer your next question, 537.07 is prorated through today's date.
All right, and you'll provide an order for the court to sign in regard to escrow, Mr. Dua?
Yes, Your Honor.
All right.
I'll send it over to Ms.
anything-
Pereira for review.
All right. So our next, our special formal hearing date is November 14th at 2:30. And I will sign the follow-up order concerning the October rent for escrow, which is my understanding 848 at this point in time. Anything else for the record in docket 22-01828? Mr. Dua?
Nothing further, Your Honor. Thank you for your consideration.
Anything, Ms. Pereira?
No, Your Honor.
All right. That's all for the record in this file. We'll see everybody back here on November 14th.
Thank you.
Thank you.
All right, Mr. Dewey, you're all set. Ms. Pereira, thank you for your appearance.
Thank you, Your Honor. Have a good afternoon.
You too. Yeah. We'll see you, Mr. Rosa.
Thank you, Judge Flores, for everything.
All right.